excuse me, jumped ahead too quickly. So when we're talking about an investigation, intake really does start before any complaint is ever received. Creating a culture where employee complaints are promptly and thoroughly addressed is good for business because it reinforces and improves employee morale, productivity, retention of your employees. Investigations can be a good way to identify ways to improve workplace practices and policies, even if the underlying allegations aren't substantiated. And obviously, it can help avoid complaints to external agencies and can avoid lawsuits. Providing regular and quality training to supervisors and human resources is essential. And I would say training to supervisors is critical. Even though a supervisor probably isn't going to be somebody who's going to be conducting an investigation, they may be the front line for an initial complaint. They also may be a front line in terms of what they're going to be the first ones to observe action that they think might be reportable. So it's important to train your supervisors so that they understand the company's discrimination, harassment, and retaliation process, how employees can make complaints and what happens from there. And policies are critical. In some states, Colorado is an example, having a harassment, discrimination, and retaliation policy and a program for complaints is actually required for an employer to rely on the affirmative defense. New York is another example of a state that has that requirement. So what are the objectives of an investigation? The goals of every investigation should really start with identifying what the concern is. So as David mentioned, sometimes you'll get a complaint and it might be 20 pages and it's filled with a lot of stuff that may not be something that you're going to investigate. So what really is motivating the complaint? What are the kernels in that complaint that require investigation? What is the ultimate concern? And then you need to gather facts about that concern, determine if there was a violation of policy or law. Obviously, if there's a violation of law, we need to investigate. I think if there's a violation of company policy, particularly if it's a policy like a harassment or discrimination policy, that should absolutely be investigated as well. You need to comply with any necessary legal disclosure obligations. When I was in-house counsel, we were traded on the Australian exchange. There was a very robust whistleblower protection law in Australia. So even if something happened in the US, we had to conduct an investigation. And if there was a reportable incident, that would have to be reported to our board of directors and possibly reported to Australia Parliament. So we were absolutely conducting investigations under that policy and making sure that we were reporting those accordingly. You want to cause as little disruption as possible to employees, clients, and to the workplace while preserving confidentiality as much as is feasible. We can never promise complete confidentiality, but we can promise that we'll only share facts on a need-to-know basis. And we want to encourage internal resolution, reporting of issues, and maintaining a fair and respectful workplace. And this goes back to where investigations really are good for business. It reinforces your policies. It's great for employee morale, and employees really do feel heard. We want to identify the root cause of what's going on, because if there is an issue, then the company absolutely has an interest in fixing that and getting to the bottom of it. And then executing necessary corrective action as necessary. And that may vary. It's not always going to be termination. It might be a written warning. It might be a verbal counseling. But you have to do the investigation and gather all the facts to determine what that appropriate corrective action might be.